Hello dear students, today we'll talk about breach of contract. Very important topic. Most of the time in business law subject you can expect one question from remedies of breach of contract. So before going to know remedies of breach of contract, we must know what is breach of contract. When a contract is executed, performed, then it will become a valid contract. Contract is executed, we can say. When contract cannot be executed, when contract is when contract could not performed, when there is some disturbance, when there is some kind of problem to perform this contract, then that we call it as a breach of contract. Are you getting it? Breach of contract means a contract which could not be performed, which could not be executed. There is some disturbance, there is some break. So that is breach of contract. How we can avoid this breach of contract? So that we call it as a remedies of breach of contract. How we can stop this breach of contract, how we can perform it, how we can avoid this. So that we are discussing into the breach of contract, remedies of breach of contract. Now we'll see here remedies of breach of contract. Simple 4 points are there, but very important. Just focus and concentrate, you can understand easily. The first one is suit for rescission. Suit for rescission means, suppose say two parties are there, any party is not willing to perform and which party is not in a position to perform, maybe due to financial problem or health problem or any other matter it can be. So when party is unable to perform, they have to inform to the first party well in advance. If they inform, automatically if that party, first party is also willing to withdraw it, they can just go ahead and they can file a suit that it is going to be cancelled due to the well in advance intimation given by the party 2. So like you can go for breach of contract, but with mutual understanding. There should be a proposal of breach of contract from one party. It should be informed to the another party properly, then it is possible. Say, let me give you a clear example. A and B had a contract. A wanted to sell his property to B. B agreed and he has given some initial amount, and after that, and they kept a due date also. Say 6 months due date is there. After 6 months, the sale proceeds are going to take place. Before 6 months, after 1 month, 2 months only, B decided that which is not possible, and B went to A and saying that I want to cancel this, and well in advance he said, if A is agreeing, then that contract can be avoided, that contract can be cancelled because of mutual understanding. If any party is not going to agree, then it has to perform, or otherwise some damages has to be paid to the party who are losing it. So that we call it as a suit of rescission. Second one is suit for special performance. Suit for special performance, there are some contracts. So these contract cannot be avoided. Suppose say, example I'll take, singing performance or dance performance is a contract. One party A is saying to B that will arrange a dance program of yours, and they have booked a hall, they have sold all the tickets, and at the end of the time or before, B is saying to A that it is not possible to perform. I want to break the contract, I want to remove from the contract. So please excuse me. So here, suit for special performance point of view, this contract cannot be avoided because it's such a case that there will be huge loss for one party. Sold the tickets and performance book, hall is booked, and all these things cannot be avoided. So this comes under the special performance, breach of special performance. Next one, suit for injunction. This is very important, suit for injunction. So in this case, injunction case, what happens is, generally when one party is willing to do something or other party is agreeing, it will become a contract. But as per the contract, both of them have to stick to their will or stick to their rules and regulations, what is decided. If one party is breaking, then other party has to stop the party to break the rules. through a case we'll discuss. It will be very clear for you to understand. Suit for injunction means here the case Warner Brothers versus Nelson. Very important and easy to understand this case, Warner Brothers versus Nelson case. So in this case, Nelson is an actress. Warner Brothers, they were the producers. They made a contract with Nelson that she is the heroine of that picture movie, and unless that movie is going to finish till that period, she is not supposed to act in any other film. But she broke the rules and she started acting in another movie. Then these people went to the court of law and held a case. Court of law held that as per the contract she should not act in another movie. So this we call it as injunction. Injunction means stopping one party to do some activity. So this injunction is going to give a protection to the first party, and where they can protect themselves from the huge losses, so that they can perform or they can conduct their activities without any disturbance. So that is what saying the suit for injunction means, taking the stay order, stopping the other party or obstructing the other party. That is, we call it as injunction, suit for injunction. And last one, suit for quantum merit. Suit for quantum merit means here if one party is making some mistake or they just broke the contract and they could not perform, if any losses happens to another party, due to that losses, up to that losses level, they are eligible to claim from the other party. Because of this party they got losses, so they are eligible to claim the losses. That we can say it as a quantum merit. Quantum merit means eligible, one party is eligible to claim the losses whatever is happened due to that unperformance, could not perform the contract, so that we can recover it. That is quantum merit. Now in quantum merit we will discuss about one case, Cott versus Umbergate Railway Company. Here Umbergate Railway Company, they have ordered 3000 chairs. Ordered 3000 chairs to this Cott company, and after receiving 400 chairs, railway company told them not to send any more chairs. We need only 1400 only, but they have ordered already 3000, means the rest of the 1600 they want to cancel it. But the company already dispatched the 1600. So in such cases it cannot be avoided. Whatever loss is getting by this company, Cott company, the railway company has to pay. The railway company has to pay. This is the law order as per this case, because ordered 43,000, 1600, 1400 only received. What about 1600? It's a loss for those company. So this company, this Cott company is eligible to take the damages as per this quantum merit. They have all the rights to get the damages. So this damages we can discuss in 4 different ways. Ordinary damage. Ordinary damage means it's a nominal, general damage. There is a possibility of damage that can be recovered. Say for example, 100 goods are sent by A to B. Out of that, 5 goods are damaged, or leak, or break, or anything. So it's quite common. That's called as ordinary damages. And the party who have received these goods due to damages, they are eligible to claim from the company. So this is ordinary. Special damages. Special damages, which is very much important, just as we have discussed in this case. Warner Brothers versus Nelson case. In that case, like any special performance, special thing is there. So for that any damages are there, that's called as special damages. This damages amount also will be always high compared to this ordinary damages. Ordinary damage amount, whatever damage happened, that amount is to be claimed from the party. But in special damage, this amount will be always much higher than the normal expectations. So this is special damages. Next one, Vindictive damages or exemplary damages. This is very important, vindictive or exemplary damages. Here, due to the goodwill and prestige of that company or family or any person, if any damages happens, these people are eligible to take the damages from the other party. The best example which you can take, marriage alliance. Engagement is over, marriage is about to perform. At this stage, when person, bride or groom is cancelling or avoiding this marriage, then this is a goodwill or a prestige for the particular person. So they are eligible to take such kind of damages. This we call it as vindictive damages. Or another example you can take. Somebody has written a false information about a particular company is under loss or company is doing fraud and all these things. So this is going to damage the goodwill of that company. This company can claim on that particular people who have created this kind of rumors. So on those people, as per this vindictive damages or exemplary damages, the company is going to get a huge amount, much amount from the other person due to the damages, due to the unbelievable frauds or something is created by the person. That's we call it as a vindictive damages. Next one is nominal damages. Nominal damages also, it's quite common and any person can receive this kind of damages. So which we can expect easily. And remote damages. Remote damages is because of a particular transaction something is happened. Only to that level they are eligible to take damages amount, not beyond that. Suppose say I have ordered 100 chairs. Out of 100, 5 are damaged. Only for 5 I am eligible to take the damages, not more than that. And rest of the 5, suppose a total 10 damaged. Rest of the 5 is due to my negligence it got damaged. Now as per this remote damage, I am eligible for only 5 chairs which are normally casually it got damaged. And due to my negligence something is happened, then it doesn't comes under this damages. So that is what saying the remote damages. So total remedies for breach of contract, what we have discussed, let me give you a recap. A breach of contract means a contract could not be performed and could not be executed. There is a non-execution due to some inconvenience, due to any kind of problems, that we call it the breach of contract. How we can avoid this breach of contract? That remedies. Remedies we have discussed 4. First one is suit of rescission. Well in advance you can just convey a message and you can drop out this contract. And suit for special performance. This cannot be avoidable due to the heavy damages which is going to bear by one party. So special performance, it has to perform, it has to execute. Next one, suit of injunction. To stop one party to do or not to do or taking a stay order from the court, that we call it as a suit of injunction. Next one is suit of quantum merit. Quantum merit means whenever a person or party is getting some damages, incurred damages due to the another party, then up to that level this first party is eligible to take the damages. They are eligible, they can take this. So that is quantum merit. Damages, we have discussed different kind of damages: ordinary damages, special damages, vindictive or exemplary damages, nominal damages and remote damages. That's it. This is about breach of contract. Very important topic. Don't leave this. Have an understanding and take your textbook and read well, prepare the notes also. It will be easy for you to understand. Hope the talk is useful, and all the business law related link is given in the description box. Serial number wise it is there, please follow it, and other subjects links also there in the description box. Please do share these videos with everyone and be in touch with me. Wish you good luck. Take care.